The court found the respondents guilty of contempt of his orders of 11th October 2024, wherein conservatory orders were issued restraining the respondents from interfering with the petitioner in the discharge of his functions as the speaker of the first respondent, pending the hearing and determination of the application. Parties were subsequently called upon to show cause why they should not be punished for contempt. So they appeared before me in person this morning and through their legal counsel. I've considered the law on contempt as captured under Section 5 of the Judicature Act, which empowers this court to mete out any appropriate punishment on parties who disobey its orders in order to uphold its authority and dignity. Contrary to the notion that the law on contempt seeks to protect the judiciary's personal interests, this court is cognizant of the fact that it is unbowed and stands as the bulwark of the administration of justice and must jealously, the court must jealously guard against abuse of court process and disregard of its orders, which are paramount principles of the rule of law. I have carefully considered the mitigation presented by the contemners and their learned counsel. I note that the contemners are elected members of the county assembly who have the critical function of steering the activities of the county assembly. They have honored the summons and appeared before this court in person to show cause and to mitigate for their actions. I've also noted that from their mitigation, they state that the actions leading to contempt were neither intended through ill will nor executed in willful or sheer disregard of this court's orders. The contemners have stated that they are remorseful and they have come across as honest and genuine in this regard. At the same time, this court is cognizant of the plight that the contemners have based on the wrangles that they have experienced at the county assembly since the commencement of this matter. It did not escape this court's attention that the sixth respondent submitted that his house has been razed down as a result of the differences arising from this matter. The contemners also indicated that they are living in fear owing to the tension arising from the case. I hold the view that the interest of justice will best be served if the existing conflicts and disagreements, based on the existing conflicts and disagreements and tension within the county assembly, this court is of the view that it will not serve the interest of justice to take further punitive action against the contemners, as this may just worsen the situation that is already prevailing in the county. The court is of the view that the action by the contemners to personally appear before this court and tender their apology paints them as parties who are genuinely remorseful and are intent on mending their ways. I'm of the view that they should be granted the opportunity to continue discharging their duties. Furthermore, it is the recommendation of this court that the contemners should take this pardon as an opportunity to seek and embrace amicable resolution for the existing conflicts or misunderstandings amongst them. As holders of state office, they have high responsibility as lawmakers in upholding the rule of law. They should therefore be at the forefront of advocating for obedience of court orders, which they have already undertaken to do. I am satisfied that the contemners have adequately purged the contempt and are deserving of the mercy of this court. So the court will pardon you, second to eighth respondents, but with a caution or a rider that it will not hesitate to mete out severe punishment for any further disobedience of its orders. Those are the orders of the court. I hope it will be that way because every time, wherever I go, everyone is asking me what is happening in Nyamira. So, msiniaibishe watu wa Nyamira. Mukae na amani, conduct your affairs in a peaceful way. Yes, Council.
This one of speaking.
Yes, Mr. Boluke.
Yeah, but we need clarification whether these petitions may specifically being transferred, having the interim orders in place.
Mr. Boluke, if you were in court earlier in the day, there was an undertaking from the respondents to your clients that they will not interfere until the application that you had is heard.
Yes, my lady.
Remember, your application has not been determined?
Yes.
My lady, a very kind permission before you pray now.
Yes.
Before very kindly, my lady, we are praying that even as the files are being transferred to Kisumu,
yes.
Lady, we are praying for a mention date on 13th, because my lady, if the files remain as they are without a mention date, then my lady, there's a possibility that they may never be moved. Very kindly, my lady, we are praying either 13th or 14th of January, once the High Court returns.
I know we return from vacation after 15th of January, so we can give you a mention date after 15th before ELRC in Kisumu.
My lady, I believe it's 13th.
13th, the court
But we can take the 15th.
After 15th, Council, suggest a date after 15th.
My lady, can we have the 16th of January?
Very well. Mentioned before ELRC on 16th.
Already that point was not meant clear before my colleague interjected. I'm beseeching the Honorable Court to make it so clear so that we don't have any other issues arising during this recess. That the interim orders do take effect and be in place.
I guess Ms. Craftsman is on board.
I think my lady may allow me. The court, we might have to avoid this. We might have to avoid this aspect of back and forth because the court has rendered itself. The court has recognized the jurisdiction that where these matters lies, and I believe upon making that kind of a move, my lady, the case of the Contempt case comes into existence automatically, that we cannot make any other further move towards any positive aspect in the case. We will appear before the learned judge on the 16th as directed. I think that's the only thing that the court can do, because the 16th date of January 2025 is merely facilitating. Therefore, the court cannot make any other pronouncement when it makes a finding that has no jurisdiction.
My lady, that is exactly why this is what what counsel has said is exactly why we are seeking your directions. This kind of interpretation and misinterpretation is why we don't want to have the back and forth that he's talking about, and seeking your interpretation as relates to the orders issued. Counsel may not, he's selective in his understanding of the Contempt case. But my lady, this court issued orders that have brought us to this ruling today.
Yes.
So if indeed the court issued an order, does it mean that they lapse on these days?
The orders have not been vacated. Did I vacate any orders?
My lady,
I do not understand where the fears are coming from.
My lady, our fears are founded. They are very well founded. If you listen to my colleague Delbert, you can see where it's coming from. His understanding of your ruling today is that the court lacks jurisdiction and the orders do not hold.
I have given
Our understanding is
I have given two rulings. Why are you looking at one? I've given
lady,
two rulings today. The court orders have not been vacated. I have simply referred the case to the right forum.
My lady, that is the clarity we needed. That it goes to advising them on how he's going to talk to his clients.
If there's any issue, I'm still on duty during vacation, you can file a certificate before me. Much obliged,
Much obliged, my lady.
Let us not have a back and forth, and let everybody play their part. Please play your part and keep your promises.
We do what we keep in promises and
That's all I
Mr. Rectemo, have a Merry Christmas.
Thank you very much.